Good morning, everyone. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So you all know I like to dive right on in. The first thing I want to talk to you all about this morning are layoffs. I'm still getting news, I think, as are we all, that companies are still laying off employees, albeit in smaller numbers, but they are still laying off employees. Some of those employees are indeed individuals from other countries that are here on employment-based visas. So I thought it would be great if we started with some of the considerations that need to be taken into account for both employees and employers when there is a layoff happening. So if you are an employer, something that you want to consider is that for some visa categories, if you lay someone off, you need to offer and pay the cost of reasonable transportation home back to their country of last residence for that employee. That is required for individuals that are in O1, H1B, H1B1, and E3 status. It is not required. That plain fare home is not required for individuals that are in TN, L1, E1, and E2 status. So that is something that you should take note of. The other thing is that if you have an employee in H1B, H1B1, E3, and O1, you should inform USCIS if their application was filed with USCIS. You should inform them that this person is no longer going to be working for you. If you are an employee, some things that you want to take, and things that you want to take under consideration. If you are an E1, an E2, an E3, an H1B, H1B1, L1, O1, or TN in TN status, you are given a 60-day grace period. And that grace period is from the day you were terminated or until the end of your I-94 card, whichever is shorter. So remember, it's from the day you were terminated or from the end of your current I-94 card, whichever time is shorter. And that is, you have a 60-day grace period. And that, again, is for E1s, E2s, E3s, H1B, H1B1, L1, O1, and TN. So you have this 60-day grace period. And some people have called me and they're like, okay, what can I do with this 60-day grace period? So you can do a few things. So during that grace period, you can, of course, use that as your wrap-up time, wrap up and, then move back to your home country or your country of last residence. If that is one thing that you choose to do, you can use that grace period to remain in the U.S. Some people have told me that, they're going to go visit some friends, they're going to go hang out, they're going to kind of just take a breath, take a beat. You can do that, but you cannot work during that grace period. Some people have used that grace period to look for other employment, and then during that grace period, have the new employer file a change of status application. So there are a couple things that people have done and that you can do while you are in that 60-day grace period. The one thing that you cannot do during that 60-day grace period is work. So please keep that in mind. If you have any questions about, strategizing either in a layoff situation, or you are an individual that has been laid off and you're not quite sure what your next steps can be or what your next options are, you are certainly welcome to reach out to the office, and we are happy to have that conversation with you. The next thing I want to talk about are paying your H-1B employees. So this is really for employers. So there's a rule that essentially says that you can't bench your H-1B employees. And what that means is, and it generally comes into play when we're talking about consultants. it means that when there may be a lull in work or there may not be a next contract to put your H-1B employee on, it means that you can't simply not pay them while you're waiting to put them on a new contract. You can't withhold salary while they are still employed, but yet you don't have a new contract to put them onto, or you don't have work for them to do. You have to pay them their salary that was listed in the application during this downtime when they are on the bench waiting for work to become available. If you are in a situation and you are not paying them during this time when work is not available to them, it becomes a wage and hour issue with the Department of Labor. And your employee can complain to the Department of Labor, and then the Department of Labor can then come in and do an audit and see if you as the employer owe that employee any back wages. So just keep that in mind, that you cannot bench your H-1B employees. And again, if you have any questions about that, or you're not quite sure if you are falling into that category, feel free to reach out. I'm happy to have that conversation with you as well. One more thing this morning on H-1B employees, or potential H-1B employees, I should say, just a quick reminder that immigration did run a second lottery last month. So if you have not checked your My USCIS account in a little while, I would recommend that you do so. You may have been selected in the second round. If you were selected, you have until early November to file that H-1B application. So if you haven't looked and logged into your My USCIS account since the initial lottery was run back in March of this year, I urge you to do so, just to see whether or not your status has changed from submitted to selected. If it now says selected, it means that you are eligible to file your H-1B application. The next thing I want to talk about is really kind of a piggyback to what we talked about last Monday, which is the Department of State visa bulletin and the employment-based visa availability. So last week we talked about how all categories were no longer getting approvals this month because the Immigration Service, all the categories except for EB2 were no longer being processed this month in September because the Immigration Service had used all of those numbers, which is actually a good thing, so that we don't have numbers sort of outstanding. And we knew that they would probably also reach the same with the EB2 category, which is using up all the numbers. So as of right now, all of the EB2 numbers have also been used. And so I know that some people are going to say that's horrible. It's actually a good thing. In the past, we've had numbers that haven't been used, which mean green cards haven't been issued. And the new fiscal year starts October 1. So the new fiscal year begins very shortly. So it's really only this last, I think, 2.5 weeks where the Immigration Service is not approving any new employment-based green cards. What they are doing is they are still accepting those applications for filing based on the September visa bulletin. So keep that in mind. And we have now the October visa bulletin. So we've seen, so that visa bulletin is out as well. So we're starting to strategize, getting the next round of cases prepped and filed for, based on that October bulletin that was just released last week. So I wanted to kind of bring you up to speed on that, especially on the EB2s. So the last thing I want to talk about this morning is another national interest waiver tip. And as we know, the national interest waiver is an EB2 green card category. The requirements for that are that your proposed endeavor must have substantial merit and national importance, that you are well positioned to advance that endeavor once the green card is issued, and on balance, it would be beneficial for the United States to waive those requirements, waiving the normal requirements. The usual requirements are filing a perm application and advertising for the role to make sure that there are no U.S. citizens who are qualified for that role. So the thing that I think some people don't know or they forget or they're just unsure of is that the documentation that we submit must relate to your chosen field and endeavor. So I had a couple calls recently where people have said, hey, I'm into, these 3 or 4 or 5 things. And, they're their passion projects. So if you have several interests, that's great. But for the national interest waiver application to be successful, you really need to niche down and be very, very specific. So an application that talks about 2 or 3 interests makes it very, very difficult for the officer to figure out where is the substantial merit, where's the national importance, are you well positioned to advance this endeavor? So you really don't want to be a jack of all trades in your national interest waiver application. You want to be very, very specific and be able to show the Immigration Service that in this one endeavor, this one industry, this one lane, and this one silo, however you want to think about it, that you have the ability to positively impact, and that you have substantial merit, it has national importance, that you have the background and the qualifications and the capability to move this forward if you get the green card, and that the government should waive the normal requirements. So when you think about national interest waiver, you really want to think about it in a very specific, niched down way. So again, it's great that you have more than one interest. I would say we all do. But when it comes to your national interest waiver application, you want to make sure that you have picked an interest, picked a focus that you think will meet the requirements, and that you have the most documentation for to show the immigration officer. And as always, if you need assistance with the national interest waiver application, feel free to reach out to my office. And that is all I have for y'all this lovely Monday morning. I am Carol Williams with Williams Immigration. This is another edition of Beyond the Soundbite. Have a beautiful